Good evening to the participants of the SLW646 online class in today, 24th November 2022. Yes, participants, can anyone unmute and read what I posted on the screen? Participants, anyone can unmute and read what I posted on the screen? Okay, I will magnify it also. Welcome to the students of the SLW646 online class, Judicial Settlement, and hosted by the Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Manza, Tanzania, East Africa. So in our yesterday class, we are up to this extent, and we are dealing about the judicial settlement. So when you see the judicial settlement is the process of solving the dispute by the international tribunal in accordance with the rules set by the international law. So if any dispute would be there which want to be settled through the tribunal, so it will be done by the international tribunal and following the rules set by the international law. Here it is important to understand the expression international tribunal. So what is international tribunal? Let us see that a tribunal acquires an international status because of its jurisdiction. Because of jurisdiction, it is international, and here in that international, in the sense, in the instrument, those who are the parties and all the states, it will be held liable under that jurisdiction. Means each state would be liable if they committed any wrong in the dispute. At the present day, the International Court of Justice, although not only the tribunal, but it is indeed the most important tribunal around the globe. So ICJ, which is there in the Netherlands, The Hague, in the Netherlands, it is both the international tribunal as well as the international court on the planet globe. There are ad hoc tribunals and mixed commission also. There are different tribunals would be there based on the nature of the cases to handle it. It is important to note that the international tribunal is different from the municipal tribunal. So international tribunal jurisdiction is the global area, and the internationally it will be made, but the municipal tribunal is where the municipal area would come over there. Up to that jurisdiction, the municipal tribunal will take it. For instance, you take the Court of Appeal in the Tanzania, it is only the country, wherever the territory would be there, up to that extent, it will be held liable to trade the cases. But when you say the residence magistrate court is concerned, whatever the area, it will be covered over there, up to that extent, the residence magistrate court or the district court will take up the cases which comes under that jurisdiction. As the same suggests, international tribunal applies the international law, and similarly municipal laws are applied with the municipal tribunals. So international law, the law would be followed in the international tribunals, and the municipal law would be followed in the municipal tribunals. To what extent can international law be applied by the municipal tribunal depends entirely on the relationship between the fields of law. So at what time that municipal law will be followed in the international tribunal, it depends upon the case of the case. For instance, if you take the private international law, and there who are the parties to the contract, a very particular tribunal, or if any dispute arises over there between the two states are concerned, two state subjects are concerned, at that instance, where the cause of action arises, that country domestic law would be followed. Arbitration and settlement of the disputes by international law have become the two very important modes of settlement of the dispute today. So in the international tribunal, arbitration is there, and mediation is there, and many other factors like what we discussed earlier. These are only the tools where you can resolve the disputes either between the parties or between the states or the parties, or parties and the states, or state to state, or parties to the parties, whatever it may be. So let us see arbitration. And participant, are you there? Participants, are you there? Okay, now let us see the arbitration. Arbitration is the process of using the help, advice, and recommendations of a third party called arbitrator to settle the disputes. So arbitration, it is a process of using the help, advice, and recommendations of a third party. A third party comes over there called the arbitrator to settle the disputes. So first party, second party, the disputed party, and the third party is said to be the arbitrator, who is nowhere connected with the first party or second party, but arbitrator would be employed or appointed depending upon the will and wish of the two parties are concerned. Yeah, MDB. Why? What is MDB? What is the full form of MDB? So, welcome. The International Law Commission defines it as a procedure for the settlement of the disputes between the states by binding award on the basis of the law and as a result of the voluntary accepted undertaking. So, if you could explain this, the International Law Commission defines it as a procedure for the settlement of this dispute between the states by binding award on the basis of the law as the result of the voluntary accepted undertaking. So, where the state or voluntarily accepting undertaking, at that instant the international tribunal will undertake such a dispute and see that award will be passed. MDB, are you hearing me? Unmute and say.
Yes, Prof.
What is meant by MDB?
Macmillan.
Okay. Always join with the name. Okay, next time we do the same thing. So now, owing to the tendency of a blend civil law procedures and common law procedures, international arbitration is sometimes also referred to as a hybrid form of international dispute resolution. So international arbitration, the another name, the Kupanga Jina, we can say that it is a hybrid international dispute resolution where it is blend the civil law, blend means mix, blend the civil law procedure and common law procedures, and that's why you can say that it is a combination of both hybrid form international dispute resolution. And you know what is civil law and what is common law. Can you tell me what is civil law and what is common law? Participant, unmute and say.
Common law is more depends on more on the precedents and the judicial. Common law depends mostly on the judicial precedents. Civil law actually depends on the law written down, the statutes.
The Britishers who ruled the country where the common law will be applied, or the civil law system is not dependent upon the adversarial system, it is an inquisitorial system where the role of the judge is more than the advocate. So civil law countries are there, common law countries are there. What are the civil law countries?
United States of America.
Is it a civil law country? Even a common law also there. Germany, France, Italy, Ethiopia,
yes, it is
Eritrea.
also. It's among the countries that use a civil law.
It's a civil law country. So common law is wherever the ruled, British ruled, they imprint, that is the common law country. India is a common law country, Tanzania is a common law country, even the part of the China is a common law country, part of the US is a common law country. Is it clear?
Yes, Prof.
No. If you see the comparatively, common law is more than the civil law.
Yes.
So now let us see the International Court of Justice. It is there in The Hague, Netherlands. In the case of Qatar versus Bahrain. What is Qatar? What is Bahrain? Participants.
Regions.
These are the countries like Eritrea, Ethiopia, Uganda, Kenya, Zimbabwe, Namibia. Qatar is a country. You know Qatar capital, headquarter.
Yeah. Yes, Prof.
What is the Qatar? Now the FIFA is where is going on FIFA?
The FIFA World Cup. Yeah.
The capital is Doha. Oman capital is
Yes.
Muscat. And Bahrain, it is a country. So Qatar versus Bahrain stated that the word arbitration for the purpose of international law usually refers to the settlement of disputes between the states by judges of their own choice. So the judges of their own choice will be the people, those who will judge and settle the disputes between the states are concerned. And the arbitrator will be appointed on the agreement of the two countries. And generally the arbitrator will not belong to any one of the country. And he may be a third world country. He is a third person, a third state country. A third state, rather we can say, or third country. So an agreement was concluded between the India and Pakistan to refer the Kutch dispute to an arbitral tribunal. Consent of the parties is also obtained before the dispute comes into the existence. These are four main characteristics of arbitration is. So when the dispute between the India and Pakistan, the Kutch dispute, the Kutch is the place. It is between the Pakistan and India. So these are the four main characteristics of the arbitration is. Number one, a tribunal is constructed to hear the particular, constructed in the sense a tribunal is formed to hear the particular case only, and its composition is also majorly determined by the parties to the dispute. So when the tribunal is formed, it is formed by the agreement of the two parties to the dispute. Number one. Number two, an arbitral tribunal does not determine its own jurisdiction but has to decide the dispute as submitted by the parties. So when the arbitral tribunal is concerned, it will not decide its own jurisdiction, but the jurisdiction will be decided by the agreement between the two parties, those who are dispute to the parties. Are you getting me?
Yes, Prof.
That means parties will inform the arbitral tribunal to use the jurisdiction. Even the dispute will be resolved, they will say that yes, this is the place where you have to make it out of the dispute, and the parties will agree that who will be the arbitrator, and parties also agree where the arbitral tribunal will be formed. Number three, it is required to make its award with a reference to the rules adapted for the purpose by rules which are otherwise binding. So when the tribunal would be there, whatever the rules framed by the two parties, agreement of the two parties, with that rules adapted for the purpose of, or by the rules which are otherwise binding. So when the rules are followed over there, then the rules should be binding, and the arbitral award passing by the tribunal is also binding, because the two parties agreed together to find the arbitrator tribunal. The last point is the parties are known to have control over the procedure to be followed. Parties are known to have control over the procedure to be followed. Means parties aware of the what are the procedures should be followed over there and how much it will be followed over there. The parties will decide and inform to the tribunal. The best known rules arbitration include those of the International Chamber of Commerce, ICC. If any dispute would be there between the mercantile from one country to another country under the Chambers of Commerce, then ICC would take up the issue, and it is London. The London Court of the International Arbitration, LCIA also, and the International Center for the Dispute Resolution of the American Arbitration Association, ICDR, and the rules of the Singapore International Arbitration Center, ASIAC, and the Hong Kong International Arbitration Center, HKIAC. Although the award in the Kutch case was vehemently criticized on the ground that it has political overtones, it was accepted by India. So just now I researched the ICC, LICA, ICDR, CIAC, and HKIAC. These are all the arbitration tribunals are concerned. So in Chamber of Commerce, in the trade, in the disputes, if any other dispute comes over there, and the parties will agree in the beginning only that okay, this tribunal is having the jurisdiction to entertain the case in case of any breach. So the Kutch case was vehemently criticized. The reason is it has political overtones and it was accepted by India. Even though political overtones are there, but still it will be accepted by India. But still there would be sometimes there will be bombing would be there regarding the certain areas concerned, which are sometimes occupied by the Pakistan, and they say it is our land and where the people belong ours. So anyway, that is the matter will not even to the UNO because they want to resolve the issue themselves, means India and Pakistan. So now let us go to the International Court of Justice. The headquarters of the International Court of Justice is situated in The Hague, which is in the Netherlands. It was founded on 26 June 1945, San Francisco. Originally, the purpose of the Article 34, Para 1, was to exclude the individual from the bringing claims against the state before the Permanent Court of Justice. However, a proposal was made in 1929 to the committee juries that Article 34 must be amended. However, presently, although they still don't have the access to the court in contentious cases, they can seek advisory opinion. So most of the international court of justice, where the parties will ask for the advisory opinion, or if the states having any issues or concern, okay, let it be represented in the International Court of Justice, because International Court of Justice is one of the organ of the UNO, and whatever the UNO member would be there, they have to bind the decision of the International Court of Justice. The Permanent Court of International Justice is known to be the predecessor of the ICJ. The earlier, it is a Permanent Court of Justice was there, but now it is the ICJ. Which means before the creation of the International Court of Justice, disputes of the parties were to be settled by the Permanent Court of International Justice. Suppose if I could ask you, before the formation of the ICJ, what would be the tribunal, what would be the court which will resolve the issues between the states or among the states, not between the state, among the states? Participants say.
Permanent Court of International Justice.
I appreciate. I want to see whether you are there or not. Number one, I want to make it out. Are you following or not? So, before the formation of the ICJ, there was a Permanent Court of International Justice would be there. Its jurisdiction depends entirely on the willingness of the party involved. At that time, the jurisdiction is only the unwillingness of the party. But now, if you are a member of the UNO, automatically you have to bind the decision of the ICJ, because ICJ is one of the organ of the
I'm sorry, could you repeat the question, Prof?
ICJ is one of the organ of the
There is a network problem. I didn't hear the question again.
ICJ is the organ of the
United Nations.
United Nations.
United Nations.
UNO is the sixth organ of UNO. All five organs are there in the New York. Only one organ is there in the Netherlands, Hague. Clear? Say yes. So shall I proceed?
Yes.
This, along with the arbitration, is commonly known as a judicial way of settling a dispute. What exactly the arbitration? It is nothing but judicial way of settling the dispute. Consent of the parties is a prerequisite for the case to be heard in the ICJ also. While the judges of the court are appointed by the General Assembly and the Security Council of the United Nations, the arbitrators are appointed by the parties themselves. There are three ways by which the International Court of Justice resolves the cases are that brought before it. I repeat, the judges of the court are appointed by the General Assembly, means ICJ, and the Security Council of the United Nations. The arbitrators are appointed by the parties themselves. Who will be the arbitrator? The parties will choose if it is arbitration. And there are three ways by which the International Court of Justice resolve the cases that brought before it. So naturally, the International Court of Justice resolve the issues among the states. So now let us see that what are the things. Number one, parties can settle the dispute by themselves and cases can be withdrawn by the state or court can give the verdict. Here, if the party wants, they can settle themselves the issue and cases can be withdrawn. Suppose if it is filed in the ICJ, then the parties can withdraw the cases by the states or the court can give the verdict. If the state would not withdraw the cases to make the settlement, at that instance, depending upon their arguments presented by the council in the ICJ, the verdict will be given by the ICJ. Two, International Court of Justice uses the international law and its guiding lights. So, all the states, those who are ENO, naturally, if they want, they can approach the ICJ for the getting their solution. And they follow the international instruments where the parties agreed and where the states are the parties to the agreement. Our states are agreed to the agreement or such a charter or treaty or protocol. Number third, writing by experts is also referred to. So if a jubilant writer would be there and their experts also referred, like if you want to say in the Tanzania, and who is an expert in the legal system in Tanzania? Most powerful and expert academician. Yes? If you don't know, you say we don't know. Participant, are you hearing me? Unmute and say, Siokimia.
Pass
Prof,
on.
please
Pass
repeat the
on.
question, Prof.
Who is a legal expert in academician in Tanzania?
Pass on.
Why you are taking so much time to say? Mostly that if you happen to see in the books also, sometimes they will quote the judges also. But mostly academician is concerned, Isa Ghulam, Shivji, Chris Peter Maina, Fimbo, Professor Fimbo, and even Chipeta. Do you know who is Chipeta?
A judge.
I appreciate. And whose names I have taken, who are they?
Juma.
I referred three names now. Number one, Isha Ghulam Shivji. Number two, Chris Peter Maina. Number three, Professor Fimbo. Number four, Chipeta. These are all the legal luminaries and they are the Professor Emeritus in the University of Dar es Salaam. Chipeta is a judge. I believe he is a retired judge now. Am I right?
You're right.
Okay. And of course, those who wrote a good books now, they will be taken as an experts. For instance, Lord Denning is there, England. Lord Denning, Holland, Lord Holland, H.L.A. Hortz, Dicey. These are all the legal luminaries and writers of different countries. Austin. Are you following me? So their experts, writing by the experts also referred in it. So now let us see the ICJ's primary function is known to be resolving dispute between the sovereign states. Because each state is a sovereign state. Am I right?
You're right.
Zanzibar is a sovereign state. Am I right?
Yes.
Wrong. Zanzibar is not a separate state. It is a part of the Tanzania. Okay, constitution may be different. That is a different issue again. But it is comes under the Uganda. Say Tanzania.
Tanzania.
In the private international law, we cannot treat Zanzibar as a state. It is a part of the Tanzania. Is it clear? Say yes.
Yes.
Its only state can be parties to the dispute that is brought before it. So in the ICJ, individual cannot go over there. Only state should have to represent. But ICC, even individual can file a case. That is the International Criminal Court. That is also there in The Hague. Of course, UN also encourages. Sometimes they will give some sanctions and they will give some. It's a push-up also. The International Court of Justice has recently decided the Kulbhushan Jadhav case. It's a very famous case in India. You can just type the Kulbhushan Jadhav case and you will get all the facts and where the judges, the advocates from the India argued his case. Kulbhushan Jadhav case. India and Pakistan were the parties to the dispute in this case. Jadhav was a retired Indian Navy officer and was sentenced to death by the Pakistani military court. The charges that were pressed against him were a terrorism and espionage in a major win for India. After a 4 years long battle from being arrested on 3rd March 2016, he finally sought relief after the suspension order of his hanging were delivered by the ICJ in 2019. And I have a live, recording of this argument, but I don't know where it is gone. It is one of a famous judge, of course, he is practicing in London, if I am not be mistaken, and he argued the case and he won the case in the ICJ. So, that is the matter between the Pakistan and India, and where the Pakistani government were given the sentence of death to him. But the India represented in the ICJ but won the case. In 2019, the verdict has come. And suspension order of his hanging were delivered by the ICJ in 2019. Compulsive or coercive means. So if you type Kulbhushan Jadhav case, you will get a lot of information. Compulsive or coercive means. The meaning of the word compulsive and coercive itself suggests that these are all non-peaceful means of settling the dispute. Because peaceful settlement of the dispute will be done through the negotiation, through the arbitration, the dispute can be settled. But using the gunpoint, AK-47, a machine gun, and if you want to say that whether you settle the dispute or not, that is not the peaceful settlement of dispute. Am I right?
Yes.
Suppose if I have the AK-47 with me, which is fully loaded with a magazine, and nozzle it towards you and say, do you agree to this statement? What do you say?
I agree.
You, without having the second thought, you agree, you say, yes, I agree. What will happen if you don't agree?
You get shot.
He will trigger off at least 10 to 20 bullets will be in your body. If the life is there, everything is there. If the life is not, nothing is there. So save the life first. Are you following me? Say yes.
Yes, yes, yes.
So this method may sometimes also involve force and pressure to resolve the issue raised. Force in this method does not indicate to the extent of the armed forces, but methods that are short of war. Sometimes now UNO make a force also. UNO. If any other country will not listen, are you getting the other sound also now? And the roadside sound. Are you getting it in it? I said I'm asking the questions to you.
What sounds, Prof?
Okay, there is a advertisement or something that I don't know what is that. They are making some advertisement there. They are using such a very big sound. So I don't think that you got it or not, because my sound is more than that sound. In certain cases, the UN may use the force if UNO dictates the terms to stop the harassment of the civilians or belligerents, and if they could not do so, then UN peacekeeping force will be sent to curb the such a situation. Even they want to then kill also, if they revolt. So, in general, peaceful and amicable way of settlement means there should not be any coercion or force. Restoration. Restoration is based on the principle of tit for tat, and is also a synonym for retaliation, as to say it is a technical term. Yes, do you want to ask anything?
Did you? Is it restoration or retortion?
Yeah, not restoration, retortion. R-E-T-O, I appreciate you found the point, not restoration, is a retortion. R-E-T-O-R-T-O-N. So retortion is based on the principle of tit for tat. Do you know what is tit for tat? And is also known as synonym for the retaliation, or to say it is the technical term. Suppose if anybody slaps you one time or one slap, and tit for tat is you slap one with the interest one, total two. That is tit for tat. Did you get my point? Did you get my point?
Maybe if you provide another example, Prof, because there was an scratch on the internet. I didn't hear the whole point.
Tit for tat. Example which I used just now is, if anybody throw a brick on you, brick, you know brick, B-R-I-C-K, brick.
Yes, yes.
If anybody throws a brick on you and you throw a stone on him, a big stone, it is called tit for tat. If he beats you, if he kicks you one time, you kick him two times. That is tit for tat. That is retortion. And also synonym is a retaliation to, means you retaliate, means you pay back, to say it is the technical term. It is an act done by one state in a manner similar to what has done earlier by another state. Such act done by the states
I
are
have
not illegal, but are permitted under the international law.
I have
See,
a question, Prof.
yeah, please ask.
Regarding to your first example, someone throwing a brick at you and you throw a stone. A brick and a stone, they are two different things. Does it mean like in for tit for tat, the one returning the to make an injury as he was done to, he has to have more force than he was done?
Suppose he has provided 10 grams of burden to you, you provided 20 grams of burden to him.
Okay, now I get the point, Prof. I thought maybe it was supposed to be equal. Like if you
No,
throw
no,
a
no,
brick, I
equal.
throw a brick.
No equal, no equal. More than that.
More than that.
Yeah, either force
Oh,
or any other thing.
okay, Prof. I get your point.
That is tit for tat. So, if a country is very calm, but the other country make the killing of 10 civilians or 10 army people, the other country may kill 20. That is tit for tat. Because the first country killing is illegal. So give the lesson to the country. He will not only kill the 10 with the interest, another 10, 20. So that is tit for tat. And such acts done by the states are not illegal. No. Because it is the first state who created such a nuisance, created such an offense, but are permitted under the international law. It is an effective tool of law enforcement, although the method of implementation may seem unfriendly. Naturally, one should not take the law into the hand. But on the same time, on the same tempo, on the same provocation mode, the country may do so. And it is not the friendly manner because naturally one should be friendly with the neighboring countries. That is the motto. There are numerous cases where the retortion has been used as a means of settling dispute. If anybody comes into your land and you stop him not to enter my premises without my consent, but still he comes and enter into your premises, at that instance, you cannot take out the gun and kill him. But what do? You can untie the ferocious dog so that it can attack. Because in the first time you told not to enter the premises, but still he entered the premises. So for tit for tat, what you do is a ferocious dog will be left over there and the dog will definitely bite that man or threaten that man to bite. So that to keep his life alive, he will run away from there. Is it clear? Say yes or no. Amna kimia. The classic example for a better understanding of its citizens are treated unfairly in another state. The former may also make a similar rigorous rule in respect of citizen of the later state. Suppose if one state make the ill treatment of particular sect people, then the same sect people in other country would be there. Yeah, you are welcome to the second period class of today. That is a continuation of the judicial settlement. We are dealing about the ICJ and Karibusana. Welcome to the second period, and let us continue it to the second period, SLW646. Yes, we are discussing the retortion. So in the retortion is nothing but tit for tat, or we can say the technical term for the retaliation to say it is a synonym for the retaliation. Means tit for tat is a synonym for the retaliation. Suppose if you throw a brick and you can throw the same size but is strong, but it is more powerful than the brick force impact would be there if it hits on your face. So the unfriendly manner, it is there if you do low, but one can use it, the force, the way that you want to. Then there are numerous cases on the restoration, retortion, not restoration. Retortion has been used as a means of settling dispute. The classic example for the better understanding of the citizens are treated unfairly in other state. Suppose the first state treated unfairly the another state, the farmer may also make the similar rigorous rules in the respect of the citizen of the later state. In the later state, the rigorous means more impact than the first one. The very purpose of retortion is the retaliation. So it is employed not to secure redress. The legitimate use of the retortion has been affected to a large extent by the UN Charter. In retortion, those actions cannot be legitimated taken which are likely to endanger the internal peace and security, such if taken are treated as illegal. But actually, a little amount of the retortion can be allowed, but that is not the correct way, because that is not the peace way of making the resolution. Suppose if some sect will be tortured by another state and the rigorous torture would be made by another state is not the perfect manner. But people will make it if it is a fair way, but it is not encouraged by the UN Charter. So in retortion, those actions cannot be legitimately taken. We are not supposed to take the legitimately. Suppose if any state has used a 10% force on particular sect, then the other state cannot make the 20%. Of course, they will make the 20% force on the same sect which were tortured in the other state. At the same sect people, they will torture in the another state. If they torture 10%, they will torture 20%. That is a tit for tat, retortion. But it is not the proper way to do, and it is not the legitimate way to do. And it is endanger the international peace and security, and such if taken are treated as illegal. So naturally, the patience is the best peace settlement. If any country is having such a patient to be there, brought to the notice of the International Court of Justice or the UNO take definitely an action in that matter. Regarding the gap of the first period to second period is not more than 5 minutes, because in the 5 minutes the software of my recording will be loaded in the computer. Once it is loaded in the computer, I can start it. So you need not to wait it, and you need not to go away. Be present over there and don't log out. So that's my point. Of course, the 5 minutes you can go for the even health break also. So next is, what is the next one? Can you read, anyone? Unmute and read. What is the next one?
Reprisals.
Reprisals. Now let us see what is meant by reprisal. If the problem is not solved by the restoration, the states have the right to resort to the reprisal. So in retaliation, the state can initiate such a proceedings where the problem may be resolved. However, reprisal is one such a method that can only be restored against a state when it has indulged in some illegal or inappropriate activity. The method and the process of the reprisal were clearly defined in Naulila case, that is Germany versus Portugal. In retortion, we'll make the tit for tat. If the 10% force is used and the other country uses the 20% force, but after the retortion also, if the dispute is not resolved, then the next step is reprisal. In the reprisal, it can be restored against the state, resorted against the state when it has indulged in some illegal or inappropriate activity. When other state is illegal and inappropriate activity, then the other state can take advantage of the reprisals. The method and the process of the reprisal were clearly defined in the Nauli law case, that is Germany versus Portugal. For example, Israel has resorted to reprisal many times against the Lebanon. Means either the waging war or repressing or attacking the Lebanon. It was
I have a
bombarded
question,
those.
Prof.
Yes,
I have a question.
yes, please.
Before you read this example of Israel,
Yeah.
could you give a simple example so as this explanation of reprisal I could understand it more?
Yeah, yeah. If you read this Lebanon, it is easily known. The example which I am reading now, it will be known what is the reprisal. Israel has restored to reprisal many times against the Lebanon. It has bombarded those regions of Lebanon where the Arab territories attacked the territory of Israelites. When the Arab territory were attacked the territory of Israel, then Israel bombarded the region of Lebanon. So they used to take the more bombarding and killing, and even they encroach in it when retortion is not a remedy at that time. Means if the excess use of force is made by using the weapons. The members of the unit cannot indulge in a reprisal of such a type which endangers the international peace and security. Why the Arab world attacked the territory of Israel? So in reprisal, what they did it know? They bombarded the Lebanon areas. And Lebanon also a Muslim country. Are you following me? Arab also a Muslim country. Are you following me? Jordan also a Muslim country. Pakistan also a Muslim country. Tanzania?
It is neither of the two. It is both. It is
They don't name either Christian
coexist.
country or they don't name as a Muslim country. Kama qaida. And India is a secular country. But Hinduism is more there now in the India. Okay, now let us see that a reprisal means if you do a particular thing, in other way we attack the particular people more. Those who belongs to the Islamic country. Israel is not an Islamic country. It is a Jewish country. But still, it is surviving around the all enemies. Are you following me? So now the member of the unit cannot indulge in a reprisal. So UNO cannot indulge in a reprisal of such a type, which endangers the international peace and security. The reason is they started it and they have given the reply to it. If they don't start it, they don't give the reply. See, in the Ukraine and Russia, whether the UN has entered in that field. Yes. UN has taken interference in the Ukraine and Russia.
No.
To my answer also no, because it is a retortion and it is a reprisal. Why the Ukraine should have to make the lion, instead of sleeping the lion to sleep, the Ukraine made a lion to wake up. Do you think the lion will wake up, he will keep quiet to the person who woke him? The lion will kill him. Am I right?
Yes, Prof.
What will happen if you touch a beehive?
You get stung by a bee.
By the new key. And you may also consequently die also. if you don't remove the strings of the poison. Am I right?
Yes.
So it is commonly accepted that reprisal becomes a justified and legal when other country has committed an international tort or violated the norms of the international law. Why the other country bombard the Israel? Then the Israel also bombard some of the area of the Lebanon. Read that. This point you will understand what is reprisal. Read this line. I say read.
It is commonly accepted that reprisal becomes justified and legal when the other country has committed an international tort or violates the norms of international law.
If they violate the international law, if he committed the international tort, then reprisal becomes a justified and legal. Is it clear now?
Yes.
So that is the point. In the provocative action and reprisal, there must be an adequate proportion to this. In proportion to the violation, the damage should be caused. But in the reprisal, one thing is there, not tit for tat. But it is at least proportionate, you can make it out. In the provocative, provocative action. If you provocate another man and reprisal, there must be an adequate proportionate that is in proportionate to the violation. If the violation is 10%, you should also do the 10%. Not in retaliation. Retaliation is 20% or more than 10%. The damage should be caused. The reprisal is valid only when demand for the reparation was made and this was not fulfilled. The reprisal body only when demand for the reparation was made and this was not fulfilled. That means it is valid at that instant only when the proportionate damage could be recovered. Reparation means paying back in other way. Then it can be reprisal will be allowed. Otherwise, it's not. Next is embargo. Embargo is of a Spanish origin. It is also a kind of reprisal. Ordinarily, it means detention. But in the international, it has a technical meaning of detention of ships in port. If the ship belongs to a state which has committed an international tort, has committed some other international wrong, and is available in the territorial water of the state against which the wrong has been committed, then such vessels can be restrained from traveling through that area as a matter of right by the other state. See, the other state has committed an international tort or a force or any violation of the international rules. If that country's ship is traveling from that country which was suffered the loss, then that state can detain such a ship or a vessel as embargo to take the retaliation. To take the retaliation. That is the restraint from the traveling although the area as a matter of right by the other state. So the purpose of such an embargo is to compel another state to settle the dispute. They want to see that, compel them, force them to settle the dispute either by paying the damages or accepting certain conditions. Then the ship will be released. In reprisals, also vessel of one of the state may be detained by another state. Even reprisal also it can be done. If the vessel is detained for the purpose of seeking redressal, embargo is deemed as a form of reprisal. Suppose if you want to press any other person to pay the damages or to agree for the terms and conditions, then such a thing will come under the embargo if the ship is detained. But if the detention is for any other purpose, it is not regarded as a reprisal. But if the ship is detained to rob all the material from the ship, it is not reprisal. Are you getting my point? It is a piracy. Means taking away the goods and robbing the ship, either detaining in a particular area or piracy on the high seas. Did you know what is meant by piracy? Amna kimia. Say yes or no, I don't know, or pass on.
Pass on.
Stealing while the sailing of the vessel in the high seas called piracy. You know, sea pirates means sea robbers, sea thieves. You got my point?
Yes. And does this fall to embargo or reprisal?
No. They are the thieves. It is not called embargo. But when you detain a ship to make the demand of release of certain things, to pay the damages, or if you violate the international treaties or norms and cause the harm to this state, and this state is having a right to detain the ship till the demands are met. That is embargo. Embargo may be applied individually or collectively under the authority of the United Nations. Maintaining the international peace and security still remains the most important prerequisite. Suppose somebody's sheep or cow or a bull grazed in your land, what do you do?
Prof, I have a question.
See, first you give the answer to my question, then I will give the answer to your question.
Okay, could you repeat your question, Prof?
Suppose if anybody's sheep or a cow grazed in your land, what do you do?
Anybody's sheep or a cow grazed on my land?
Yeah.
That's trespassing. So I'll seek for that person to pay the damages that the sheep or the cow may have caused me by them grazing along my farm.
So you will send a telegram to him, you send a letter to him, you send a message to him.
Yes.
You don't send any message to him. You don't send anything to him. What do? You detain the sheep in your land. Then in the evening, that fellow will come where the sheep has gone. So he will surround all the area, then find the sheep in your house.
Then what if you were not around, the cows and the sheep?
How could you know that sheep belongs to your neighbor? Tell me, how could you know that sheep belongs to your neighbor?
That's what my point. My point actually went around, and the sheep and the cows grazed your land, and they left, and you knew that these are maybe these are footprints of the cows or the sheep, but you know the kind of person that actually passes here with this kind of.
At the time, you only detain the sheep unless, suppose if you know that belongs to so-and-so person, then you can inform him. Your sheep has grazed in my land and destroyed this much, my bamia. Najua bamia?
Yes.
Say in Kingreza.
No, I do not know it I've forgotten what in English it says.
Lady fingers.
Lady?
Fingers.
Lady fingers. Lady fingers, yeah.
Okay, now you ask the question.
It states here, if the vessel is detained for the purpose of seeking redressal, embargo is deemed as a form of reprisal. But if the detention is for any other purpose, then it is not regarded as
Embargo.
reprisals. So my question is, um, let's take an example of piracy. Is piracy considered?
Piracy is entirely stealing for thief. It is not embargo.
It is not embargo. So it's how, if it's going to be treated here, is it going to be treated as a form of reprisal, or is it
Thief
embargo?
is stealing. Neither is a repatriation, nor the retortion, nor a embargo.
Okay. I was
Any doubt?
asking for an example, maybe an example of an international tort that may lead to embargo or reprisal, so as I can have that as an
If the
example.
vessel is detained, it is an embargo. If any other retaliation would be there, that is a repatriation. If taking the retaliation in the form of a little bit more force is called retortion. Restoration. Retortion.
Retortion.
Using the force more than that is retortion. Reprisal, if you caused in harm to another person, he will cause the harm to another person to make the repatriation. And in
Okay.
embargo, if an international tort is committed by the other state or the harm is caused to another state, the another state could retain the vessel of that state which caused such a international loss, and they will detain it till the demand is made over there. But they don't steal.
Okay.
They don't steal. But stealing on the high seas, and the people will not detain the harbor. They steal when they steal the vessel while it is in sail.
Okay. Okay.
So piracy will not come in any one of the category.
Okay.
It's a completely illegal act, stealing act. Any doubt?
No, now I get the complete distinction of the three.
Shall I proceed?
So retortion, yes, you can proceed, Prof.
Yeah. So now, if the vessel is detained for the purpose of the seeking redressal, embargo is deemed as a form of reprisal. Okay. But if the detention is for any other purpose, then it is not regarded as a reprisal. Embargo may be applied individually or collectively under the authority of the United Nations. Maintaining the international peace and security still remain the most important prerequisite. See, whatever the activity, do it, but see that peace will not be disturbed. Pacific blockade. A Pacific blockade is a blockade used for the purpose of bringing pressure exercised by a greater power to bear on a weaker state without actual action. It is a blockade used for the purpose of bringing pressure exercised by a greater power to bear on a weaker state without actual action. So when the coast of a state is blocked by another state for the process of preventing ingress of the vessels of all nations by use of the warships and other means in order to exercise economic and political pressure on that state, the act is specifically called a blockade. So here the blockade means if any country blocked their purpose bringing the pressure on the weaker sections, do you know all the weaker countries will make all diplomatic relations will be curtailed, export and import will be not made, and they force that state which acted on a weaker state, all other countries will together make such a thing, and that is called Pacific blockade. When the coast of the state is blocked by another state, when the coast of state is blocked by another state for the purpose of preventing ingress of vessels for all nations by use of warships Other means, in order to exercise economic and political pressure on that state, the act is specifically called bracket. You know, Lebanon, Libya, not Lebanon, Libya. Libya is a Islamic country and is a self-independent country. It will not try to make the export from any other country. They try to develop of their own resources. But economic sanctions were made by the USA because they want to pressurize something on them. And still the Libya survived. But later on, the USA removed the economic sanctions. For a certain period it is made, but it is survived. But later on, they removed the economic sanctions over the state, and now it is Libya. Yes, it's a free state where the people are Islamic in nature. So here, Pacific blockade means other people will try to make such a sanction over them. They see that the pressure will be brought on it. So requirement for a Pacific blockade are similar to those that are needed for a normal blockade during a wartime. It has been regarded as an aggressive means for the settlement of international dispute because it consists in a temporary suspension of the commerce and the offending state by closing the access to coast. You know that Panama Canal. See, if the Panama Canal will not be opened over there, then the vessel should have to pass on the various long distance. I think I am right by using the Panama Canal. So now they are allowing the vessels to pass on there, but they will take the toll tax, like some tax they will impose in each ship to pass from that canal. Because that is only the revenue for them, most of the revenue for them. Are you following me?
I am.
Zimbabwe. Is it Zimbabwe or Zambia? No, Zimbabwe. Zambia. Zambia is a landlocked country. Am I right?
I'm not sure.
Do you know what is landlocked country?
No.
That country doesn't have the sea adjacent to it. Surrounded by all the land of different countries. So that country we can say landlocked country. Did you get my point?
Yes, I get your point.
Tanzania is a landlocked country.
No.
Because one side it is the Indian Ocean. Do you know that the lot of revenue come through the harbor because goods transported in the ship will be transported by road from the harbor of the Dar es Salaam to Zambia. Because Zambia is a landlocked country. The greatest, the heaviest transport is not land transport, not air transport. What transport it is? What transport it is?
Could you repeat?
The most of the goods in the world will not be transported by the air, not transported by the land. It is only transported by the... Oh, you are taking that much time. Water, sailing, ships, vessels.
The thing is the network, Prof, because it's scratchy.
What is that?
There is a moment you're talking and there is a moment it is total quietness. And then when it comes back, there is a phrase you're talking, then there's a question. So I do not actually hear what you said.
The most of the transport is done either through the land or through the air or through the water. The
Yes.
most of the transport will be done either on land, on air, on water.
Yes, yes, Prof.
What is? Give the answer. I gave the three options.
Mostly by water
It is the water
and
transport
land.
where the transport of the goods will be carried from one country to another country.
Yes.
It is only the ships, vessels carry it, cargo vessels.
Yes.
See, to make you understand, I have to say the same dialogue at least 3 to 4 times.
Because of the network, Prof.
You sit in such a place where the signals are strong. If you want, you can go to the even gate also and sit there and listen my lecture. Are you following me?
Yes, Prof.
That means you can travel to a certain extent and sit where the signals are more. And don't sit at the place where the signals are less. In your own house, in some places signals are weak, in some places signals are strong. So you move to that place where the signals are strong and sit over there. Sir, there is a kilele kilele. Use your headphone. The kilele will not come out. It will be lessened, reduced. Okay, now let us come to the when the coast of the state is blocked by another state. So that is a blockade is called. Requirement of the Pacific blockade are similar to those that are needed for a normal blockade during the wartime. It has been regarded as an aggressive means for the settlement of the international disputes because it consists a temporary suspension of the commerce for the offending state by closing the access to the coast. See, temporary suspend of the using the ships to pass on it, they will blockade it to make the pressure on the other country to see that the blockade would be removed. And what the other country will do, the other country will make the pressure on that country which are causing the international loss to this country. Because of you, and that fellow is not allowing our ships to sail from their land, from their territorial waters, and is blocking us. So all other country will make the force on him to see that the whatever the damage is caused to this country should be compensated. Do you know that when a small accident or anything happen on the roadside, and that fellow creating the nuisance by stopping all the traffic because he wants that his demand should be fulfilled, that the people, those who are behind it, also force them. See, whatever is demanding the genuine demand, please pay it and see the traffic should be free. So if the genuine demand would be there, then naturally that fellow will pay the amount. Then only the back vehicles which are there standing in the queue may pass because his vehicle is in the front and which is blocked by this fellow. In the same manner, if any person blocks, if any ship retaining his reprisal, retaining his demand to be completed, then all the ships which are going through that route will be blocked. Then the other ship owner will come and ask him to resolve the issue. And definitely, when the 10 to 20 people are crying and ask him to resolve the issue may be resolved. And he will allow the vessels to pass on. And all the vessels will pass on, those who are waiting in the queue. That is the same example we can make the specific blockade is concerned. At present, while a blockade is illegal, actually the blockade is illegal, if you strictly speaking. At present, while blockade is illegal when it is applied by the state individually, if you individually apply it or collectively blockade applied under the authority of the Security Council and settle the dispute in a lawful manner. If you, for own purposes, to benefit yourself, you make the blockade, that is illegal. But you want to make the collective demand of a particular thing, then the UN Security Council will give the sanction to blockade it. Then automatically the other country which was suffering or the other people will force him to fulfill the international laws or compensation to this country where the other country caused to this country. Are you following me?
Yes.
Kenya. Kenya is having a port, harbor, I'm speaking. Kenya is having a harbor, I'm asking. Don't be Kimia. Either you know it, you tell me. Or I say just pass on, or I don't know. Mombasa. Mombasa is the Indian Ocean.
Yes, you have.
But why you are not giving the answer? Mombasa comes in Kenya or comes in Tanga?
Kenya.
Mombasa is a big harbor or Tanzania is a big harbor?
Yes.
What yes? I asked the question. Mombasa is a big harbor or a Tanzania is a big harbor?
I think Tanzania.
Then you say yes. Do you know most of the foreign goods you will get it in Zanzibar, then in Tanzania? Why?
It's along the coast.
See, there is a more security would be there in the harbor of Dar es Salaam, and the less security would be there at the Zanzibar. Because the small boats or barges go to the big ships and they will take the all without paying custom, all foreign goods, they will take it and they will come to the Zanzibar because of various places you can enter into the Zanzibar. Am I right?
Yes, yes, Prof.
Because total Zanzibar is surrounded by total
Low
Zanzibar
security.
is surrounded by
Low security.
water and less possibility of the security. Because if the one door is there, security is more. If the 100 door is there, security is less. If the no door is there, anyone can enter. So you will get the lot of goods in Zanzibar when you compare to the Tanzania. You will get the all foreign watches. You will all get the foreign goods at the low price because it's the custom free. Of course, they smuggle it without paying the custom duty. So hence the cost is less. Of course, they will not openly sell it. They will sell it in the clandestine. There is a different issue. So it has been regarded as an consist. So it is not the proper way to block it for the individual means unless a collective thing should be there and the Security Council will allow the embargo or a blockade, Pacific blockade.
working on social media for my clients. I create a lot of video content